The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. The next case is State versus Strudwick, and we'll hear from the appellant.
Good afternoon, or actually still good morning. I'm Sonia Calloway Durham on behalf of the state. May it please the court. I'd like to reserve 5 minutes for rebuttal. The court's order of satellite-based monitoring is a constitutional search if it's reasonable based on the totality of the circumstances. In this case, the assignment of error, that being whether or not the Court of Appeals erred in reversing the trial court's order for satellite-based monitoring, subsumes two issues. The first being the expansion of Grady 3 by placing the burden on the state to forecast future circumstances, and the second being the standard of review as noted by this court in Grady 3 and numerous other decisions that in reviewing a trial court order, the court is strictly limited to determining the judge's underlying findings of fact are supported by competent evidence, and that whether those findings of fact in turn support the judge's ultimate conclusions of law. The state believes that in erring as to both, the court ultimately erred in reversing the trial court's order. In this case, instead of acknowledging the competent evidence presented to the trial court and the binding findings of fact made therefrom, and the binding conclusions of law based upon an accurate analysis of the law, the Court of Appeals simply compared this case to another Court of Appeals opinion and ruled that the order was unconstitutional. However, just as the findings of fact were binding on the court and the conclusions of law were also binding, Grady 3 is also the binding precedent. This defendant, an offender of an aggravated offense, that being that he brutally raped, beat, sodomized, and sodomized a complete stranger, a 64-year-old woman out walking her dog along a public greenway, is not within the limited class of offenders for Grady 3. As such, the satellite-based monitoring statutes in question are still constitutional as applied to him and therefore binding.
Ms. Calloway Durham, help me a little bit understand the procedural posture that we've got before us in this case. As I understand it, we're here on the state's appeal based upon Judge Tyson's dissent in the Court of Appeals. Is that correct?
That is accurate, and the dissent made several points, the main point of which was that the trial court erred, that the Court of Appeals erred, namely by expanding the jurisprudence of this court by requiring the state to forecast future circumstances, and by
go ahead.
By putting the burden on the state on appeal to prove the constitutionality of the statutes, when in fact the burden was on the defendant to rebut the constitutionality of the statutes, which are presumed, and also based on the dissent's finding that the trial court order was based upon conclusions of law and findings of fact, that the monitoring would have been reasonable and that there was efficacy in doing so.
Is it your contention that I've read the dissent several times, and I'm trying to sort of get to understand what Judge Tyson's point was. He seemed to put a fair amount of emphasis upon the fact that the defendant would still be under supervision for some period of time after the expiration of his sentence. To what extent do you think that Judge Tyson's dissent rests on that?
Judge Tyson's dissent in part rests on that, in that Judge Tyson made very clear that he has a limited expectation of privacy, whether he's out of prison on supervised release or still in prison, and that in fact he has even less of a right to expectation of privacy while he's in prison. He actually has more of a right while he's out under supervision, and the state would argue even more while he's out unsupervised but being monitored. In other words, Judge Tyson made it clear that the alternative is for him to return to prison where he has even less rights. The part of what the judge found and the testimony was, which was competent, there were 3 sets of competent evidence, that being the court's finding that the defendant had stipulated to the factual basis for the crime, Officer Jones's testimony, which was at length and on cross about not just the nature of satellite-based monitoring, but how the device worked, the nature of exclusion zones, and whether you're supervised or unsupervised and how that worked. She made those distinctions during her testimony. So Judge Tyson's dissent was about the fact that while you are supervised, and I know Officer Jones testified at length and on cross about the first 60 months being supervised and thereafter being unsupervised but monitored in Raleigh. Whatever the case, he would have more privacy rights, but fewer than he does in prison. But as the court found in its conclusions of law, he would still have a diminished expectation of privacy than the average person, and a diminished expectation of privacy than what society objectively would view as reasonable, given the nature of his offense. Did I answer your question?
I think so. Yes, ma'am.
Okay.
If I could follow up, as long as we're talking about the impact of the fact that this defendant is not likely to be released for I think it's 20, 30, 40 years. Is there anything in the statute that prevents the state from just continuing the satellite-based monitoring hearing until such time as he is close to being at the end of his post-release supervision?
The way the statutes, I'm sorry.
Well, go ahead.
The way the statutes are written and the forms that the courts came up with, that being the 615, which is what is done ancillary or in a short period of time after sentencing, if not exactly at sentencing, or the 616, which is a bring back hearing. Grady 3 was a bring back hearing. So we've already got an order in place. In Grady, there was not an order in place, which is why there was a 616 form for a bring back hearing. So the statutes differ depending on whether or not, I mean, they say essentially the same thing, but they're different provisions of the statutes that apply to whether it's a bring back hearing or a hearing that's done in tandem or sometime close to sentencing, which was the case here. So that being said, the order is already in place. However, there is another matter that the state brought up in its memorandum of additional authority that is currently before the Court of Appeals, for which there was an oral argument a couple of weeks ago, and that is State versus Billings, wherein the state has argued and the Court of Appeals is considering whether or not, just as any civil order is subject to the rules of civil procedure, a motion in the cause or a motion under Rule 60b-60 with extraordinary circumstances, whether or not for purposes of a rehearing, as was the case there, or I believe what Your Honor is referencing, that would be applicable. And the state's position is that the rules of civil procedure do still apply. This is a civil order. There is no caveat under the rules of civil procedure just because this is a satellite-based monitoring order. But as far as the state being able to have a bring back hearing, we would not be able to do that. But there are still the rules of civil procedure for any matter where there are extraordinary circumstances.
Well, given that this is a civil proceeding, does that mean that the doctrines of ripeness also should apply here? And I ask that because it seems that both the majority and the dissent in this case acknowledge the difficulties of assessing the constitutional factors, not only the nature of the privacy rights, which you've identified might be different depending on what status the defendant is in, but also the nature of the state's interest, the nature of the intrusion on the privacy rights. Satellite-based monitoring may occur in very different ways as technology evolves. Isn't the state in a much better position to present the evidence that it has the burden of presenting to show the reasonableness of a warrantless search? Isn't the state in a better position to do that closer to the time of the actual imposition of the satellite-based monitoring?
Well, given that the United States Supreme Court has essentially addressed issues of changes in technology that are different in the future than they are at the time of a warrant, or quite frankly, at the time the framers framed the Constitution, the United States Supreme Court in Keola, which is also a matter that the state noted in its memorandum of additional authority, made clear that there's never been a rule in which the Fourth Amendment guarantees are tied to the quantity or the quality of the information obtained during a search. That prohibiting intimate details would be impractical in the application and fail to provide a workable accommodation between the needs of the law enforcement agencies and the interest, which is the interest of the government, under the Fourth Amendment. There's no necessary connection, the court ruled, between the sophistication of surveillance equipment and the intimacy of those details, and that the court ruled that it would have to develop jurisprudence on which details are intimate and which ones are not. And even if it was able to do so, police would not know in advance which was which. So that having been said, there's nothing either in this court's jurisprudence or in the statutes or in the U.S. Supreme Court's jurisprudence that forecloses the state to have a reasonable search simply because there is technology that may change in the future or that may become more sophisticated than it was at the time.
Justice Ervin asked you earlier about a construction that you had of Judge Tyson's dissent. I wanted to ask you, in the breadth of these cases that have come up in the Court of Appeals, that have come up to the state Supreme Court and have been remanded, Judge Tyson talks about what he considers to be the Court of Appeals, to use his phrase, broad expansions of Grady 3. Do you see there having been a broad expansion in this present case? And if so, in what ways?
The broad expansion, again, is requiring the state to prove future circumstances for which Grady 3 did not mandate, either in as applied to the defendant in that case, and more importantly, given that the limited holding of Grady 3 does not make the current statutes unconstitutional as applied to this defendant, by requiring the state to prove things that no case law before this court, namely Grady 3, have mandated. By doing so, the Court of Appeals thereby expanded Grady 3. They did not look at what Grady 3 required, which is that you look at the competent evidence, that you look at the findings of fact based on that competent evidence, and if they're based on it, it's binding on appeal. And then from there, you look at the conclusions of law, and if those conclusions of law based on those findings of fact are an accurate analysis of the law, which it would be under Grady 3, then that is also binding. State versus Golf in this court made clear that where the conclusions of law are an accurate analysis based on those findings and the competent evidence, they're binding on appeal. The Court of Appeals did not take into account the rules that Grady 3 put in place, that being the limitation to offenders unlike defendant, but also a continuing reiteration of the current jurisprudence, which includes the standard of review, that being the evidence presented, the conclusions of law, and the findings of fact, and whether or not those are binding, such that the Court of Appeals did not have jurisdiction to overturn the trial court's order.
Relative to that, how does the state consider the defendant in the present case as relates to the defendant in Grady 3 in terms of them being in the same classification for purposes of SBM?
They're in the same classification only so far as they both had lifetime satellite-based monitoring applied to them. The first parts of be it bring back or a hearing around the same time as sentencing, both sets of statutes within the satellite-based monitoring statutes make clear that if you are a recidivist only, a recidivist, which recidivism only is no longer applicable given Grady 3. But the other findings, that being that you're a sexually violent predator, that you have committed certain statutory offenses against minors, sexual offenses, and 3, that you're an aggravated offender, meaning that you have committed an offense that involves the sexual penetration of the vagina of someone who by force or through threat. And the Court of Appeals has made clear in State versus McCravey, which is also in the Memorandum of Additional Authority, that by definition, first-degree rape, which is what this defendant committed, is by definition an aggravated offense. In the court's conclusions of law, the first conclusion was that he committed an aggravated offense. So being that he committed an aggravated offense, that puts him in a different class of being subject to satellite-based monitoring than the defendant in Grady 3, who was only subject to it by recidivism.
Does it make a difference in any way for our analysis, in the state's view at least, that Grady was subject to immediate SBM, whereby the defendant in the present case would not be subject to SBM until multiple decades from now?
There is nothing in the statutes or in any binding case law that says that the fact that it will occur in the future precludes the constitutionality of the search. Again, the U.S. Supreme Court made clear that the sophistication of technology is not something that's considered under the Fourth Amendment. And quite frankly, the only reason that he's going to be subject to satellite-based monitoring in the future for so many years is not just that he committed the most heinous heinous sex crime there is, which is first-degree rape, but also because he pled guilty and stipulated to consecutive sentences for all the other offenses he committed. But if not for him stipulating to not only the first-degree rape, but the other offenses, he wouldn't be subject to those consecutive sentences. He agreed to that. It's his agreement, his stipulation, which is binding on this court, for which he cannot appeal, quite frankly, under the law, that places his search in the future. It's not because the state didn't opt for a 616 form, that is for bring back hearing. Under the statutes, they're allowed to do either. Because they did the 615, which was ancillary to the sentencing, there was nothing in the law that said they couldn't. Neither because of the sophistication of unknown technology, or because under the law they were allowed to go ahead and do the satellite-based monitoring hearing around the same time as the sentencing. The second conclusion of law, well, let me go back. The court there were 3 sets of competent evidence before the trial court. The stipulation to the factual basis for his plea, that being that he raped, sodomized, beat a 64-year-old woman out walking her dog along a public greenway. 2, Officer Jones's testimony, which a lot of it came out on cross as well as on direct, about the nature of the search and how satellite-based monitoring works, the difference between supervised and unsupervised, the use of exclusion zones, which were specific to the supervised monitoring, about the device itself and how it's used in probation cases, and about the distinction for supervision and SBM under supervision being exclusion zones, meaning other people who are monitored don't have those. And again, most of that information was brought out on cross. And then the static 99, which according to the statutes is not mandatory except for when you have an offense involving the physical, mental, or sexual abuse of a minor. If it's not, where it's not mandatory, it doesn't mean that the court can't have a risk assessment. There was not a risk assessment, which this court was concerned about in Grady 3. However, there was one in this case, even though the defendant was subject to lifetime satellite-based monitoring. And given the fact that there was competent evidence in addition to the static 99, that meant that the static 99 in and of itself was also competent for purposes of determining his risk. And his risk goes to the level of his expectation of privacy, which is diminished, which was yet again another finding, conclusion of law that the trial court made. With those three sets of competent evidence, the court made 27 findings of fact. Many of them, I won't belabor the court with all 27, but one, that he stipulated to the factual basis for the rape. Number 5, Officer Jones's testimony. Number 13, that those supervised are not monitored, unsupervised, are not monitored in the office, local office, but in Raleigh. Number 23, about the purpose of the program itself. And number 25 through 27, the static 99. The court then made 11 conclusions of law. Again, I won't belabor the court with all 11, but most importantly, that number 1, he committed an aggravated offense under State versus Golf, and that is binding on the Court of Appeals. If it is an accurate analysis of the law, it's an accurate analysis under State versus McCravey, because by definition, first-degree rape is an aggravated offense. Number 2, he concluded that he's subject to lifetime satellite-based monitoring, again, based on aggravation.
Miss Calloway Durham, let me interrupt you just a second. I'm not sure I'm following you. Is it your argument that, assuming that the trial court found and concluded that the defendant was convicted of an aggravated offense, that fact and that fact alone ends the Constitution?
No, sir. It just
Okay.
means that he's subject to. Subject
Right.
being the first prong. If you're subject to satellite-based monitoring, the second prong is whether or not it's reasonable.
So it's not your contention then that the various findings that you have gone through for us and the various conclusions that you've gone through for us in the inquiry that the trial court's required to make?
I'm not sure I understood the question, but let me see if I answered it, then tell me if I answered correctly. The state's position is that the second conclusion is that he's subject to satellite-based monitoring for lifetime is simply because under the statute, there are sets of the most heinous crimes for the most violent offenders that the statute still applied to under Grady 3 that makes them subject to lifetime-based monitoring.
And I guess my
reasonable.
concern is that I think the issue here is not whether it's a statutory matter. The defendant is subject to lifetime satellite-based monitoring. The issue here is, given that fact, is the position of lifetime satellite-based monitoring on the defendant reasonable? Is that term used in the Fourth Amendment?
Yes, Your Honor, and I just hadn't gotten to that point. I was just making a point that all of his conclusions, the ones that are most pertinent to these issues, are findings that were based on a legal analysis that was accurate, for which
So all you're doing at this point is describing the trial court's discussion of the statutory issues.
I'm going through the court's conclusions of law and trying to make a point that they were all legally accurate, such that under State versus Golf, and they were binding on the Court of Appeals, such that they should not have overturned the order. But
the reason I'm having some trouble here is that I think you agreed a minute ago that whether the defendant was subject to satellite-based monitoring as a statutory matter didn't answer the question of whether the requirements of the Fourth Amendment were satisfied.
Correct. I have not got there yet. That's correct. I'm sorry.
So you're not at this point in your argument discussing the Fourth Amendment issue.
Not yet. I was getting there to say that his next conclusion of law is that satellite-based monitoring is a search, which under Grady is an accurate analysis of the law, Grady 1, Number 4, he concluded that defendant has a diminished expectation of privacy. Number 5, that although lifetime satellite-based monitoring is an intrusion, under the totality of the circumstances, lifetime satellite-based monitoring is reasonable. And number 9, that it did not increase his maximum punishment. Number 10, that there was no substantive due process violation, that the release of information will further the government information interest of public safety so long as the information is rationally related to the furtherance of those goals, and that it did not infringe on any fundamental right. And number 11, that it was constitutional on its face and as applied. So as far as the Fourth Amendment is concerned, we don't get to, as far back as Mapp versus Ohio, the U.S. Supreme Court has made clear that the Fourth Amendment is applicable to the states through the due process provisions of the 14th Amendment. In doing so, the trial court was making clear that to get to the Fourth Amendment, we have already crossed a hurdle as required under the substantive due process requirements of the 14th Amendment, and that their legitimate government interest was rationally related to the statutes themselves. And as far back again as Mapp versus Ohio, that has been clear.
Counsel, you're within your rebuttal time.
Okay, I'll reserve my time. Thank you.
We'll hear from the appellee.
May it please the court. Good afternoon. I'm Assistant Appellate Defender Nicholas Woomer-Dieters on behalf of the appellee, Mr. Strudwick. The majority below quoted Yogi Berra's observation that it's tough to make predictions, especially about the future. This is not a throwaway line. It highlights a fundamental problem with our SBM statutes that emerges in cases like this one, where a defendant receives a lengthy sentence. When SBM was enacted, it was intended to be a civil regulatory program. And at that time, no one could have predicted that the United States Supreme Court would rule that North Carolina's SBM program affects a Fourth Amendment search. Grady versus North Carolina was decided more than 6 years ago, but the General Assembly has not updated the SBM statutes to bring them in conformity with that decision. That failure has led directly to where we find ourselves today. Satellite-based monitoring begins when a defendant is released from prison. But Section 14-208.40A requires that satellite-based monitoring be imposed at the time of sentencing. Mr. Strudwick's plea agreement called for the imposition of 3 consecutive sentences totaling 360 to 516 months of imprisonment. And if you do the math, that's 30 to 43 years total sentence. At the satellite-based monitoring hearing, Mr. Strudwick raised an as-applied Fourth Amendment challenge to the imposition of satellite-based monitoring pursuant to Grady versus North Carolina. So the state had to demonstrate that it was reasonable to subject Mr. Strudwick to a 24/7 search 30 to 43 years in the future. And as the majority below noted, that was an impossible burden. It was impossible under both Grady versus North Carolina and Grady 3. This court does not need to expand Grady 3 to affirm the majority below. This case is controlled by the United States Supreme Court's holding that SBM affects a Fourth Amendment search.
Well, let me ask you the question that Justice Earls asked Ms. Callaway Durham, rather, that is there anything that would prevent the state? You mentioned the requirement that it be done at sentencing, but then you've also got this structure for bring back hearings that contemplates that might not actually happen. Is there anything that would prohibit the state from seeking satellite-based monitoring in a case like this one, where the defendant is going to be incarcerated for a substantial period of time, that is to wait until we're getting close to the end of the period of actual imprisonment?
Sure, Your Honor. Well, the Part A of 14-208.40A provides that when an offender is convicted of a reportable conviction, and there's no question that he was, that during the sentencing phase, the district attorney shall present to the court any evidence, and then, that he meets the criteria for satellite-based monitoring. Can that be continued? I mean, there was actually a 4-month continuance in this case. It seems to me that the parties were attempting to make a good faith, comply with the statute in good faith. But as I read that statute, and I think, as the parties, the prosecutor and the defense attorney read the statute, it seems like, that determination had to be made at sentencing because he wasn't in a bring back hearing type of posture. So.
Thank you.
Would you agree that SBM is a less onerous situation than parolees agreeing to warrantless searches?
I would agree with that.
So we know that parolees and warrantless searches are constitutional under Sampson.
That's correct.
So would it then be your position that you're not contesting SBM during the term of parole?
That'd be correct in this case, Your Honor.
So then it began, so then our analysis is after a term of parole, is SBM an unconstitutional, unreasonable search, correct?
I would agree with that, Your Honor.
So why is the provision that after 1 year, the defendant can petition the court to have SBM discontinued? And at that point, if it is not discontinued, he would be able to seek review of that decision. Why is that not an adequate protection under all these circumstances?
Your Honor, if I as I recall, that provision, the provision that you're referring to, doesn't allow the defendant to petition the court, but rather to the Probation and Parole Commission. And as this court kind of addressed that provision briefly in the Grady 3 decision. And so my answer to that would be that there's not actual judicial determination of reasonableness at that time, but rather it's an opportunity to petition some sort of administrative body to make that determination. So it doesn't provide him the same protections that he would be getting when the determination is being made up front.
So that same provision is called into question with regard to people who have a term of years sentence that then provides for the possibility of parole after a certain period of time. If those possibilities of parole are never granted, if you will, or in this situation, if the parole, the post-release supervision and parole commission just rubber stamps these things, why would that not be at that point the time to contest whether this is a meaningful hearing or if it's just a facade?
Because I think that the time when the lifetime satellite-based monitoring order is imposed is at the time of sentencing. That's the time when the defendant is before the judge, when he can raise the constitutional objections to the hearing, and so that's really the point where the order is imposed, and so that's the appropriate time for him to make these arguments. The statutes do not provide for any other kind of judicial review of a satellite-based monitoring order. And that's why I don't think that the provision of being able to go to the parole commission cures the problem that this case presents, which is that courts are being forced to look ahead decades into the future to determine the reasonableness of a search.
But you don't disagree with what the state suggested, that under the rules of civil procedure, a motion could be made, setting forth whatever needed to be argued and asking the court to modify this civil order at that point.
Your Honor, I think that, there's no provision in the statutes. Now, under the rules of civil procedure, is he, can he make a motion later on? I suppose he could, but I still think that, the statutes do not provide for that kind of remedy. And so, I don't think that cures the problem of imposing satellite-based monitoring at the time of sentencing, which appears to be required by the statutes.
Let me follow up on one of the questions that the Chief Justice asked you, because it was a version. I was going to ask you a version of that one myself. I understood you to say that you did not attend that the imposition of satellite-based monitoring upon your client during a period of post-release supervision would be inappropriate. Did I understand you correctly, or did I misunderstand you?
Your Honor, what's under review in this case, in the Strudwick case, is the question of the lifetime satellite-based monitoring order that was imposed by the trial court. And in this case, none of the parties are really addressing the application of SBM beyond or during the period of post-release supervision. The question is,
let's say hypothetically somebody had raised that. And I read the part of your brief that made the very point that you just made. But let's assume, for purposes of discussion, that somebody had argued that it was permissible to impose satellite-based monitoring during a period of post-release supervision. What would and that issue was otherwise procedurally porous properly?
Right.
I'm trying to get to the merits without any surrounding procedural hiccups.
Sure, Your Honor.
What would your position be?
Well, I think that, under post-release supervision, it mandates satellite-based monitoring anyway. The distinction comes in for the penalties. So you've got it's almost kind of redundant, I guess you could say, is that under post-release supervision, he's automatically enrolled, he's automatically put under this monitoring. I don't think that satellite-based monitoring, to add on to that, it's kind of redundant. It just doesn't. It's a bit of a distinction without a difference, if you will.
Okay. What do you on a different subject? This case, as I discussed with Ms. Callaway-Durham, is here before us on the basis of Judge Tyson's dissent. What do you understand Judge Tyson's dissent to hold?
Sure. I will just confess to being a little bit confused by Judge Tyson's dissent. What he seemed to be indicating was that, he agreed that at some point, Mr. Strudwick would fall into the Grady class once his period of supervision had expired. That's his incarceration and his post-release supervision. So in that respect, it seems like the panel below agrees. Where Judge Tyson seemed to disagree with the majority is to whether it was appropriate to vacate the order at this time, and that appeared to be the basis of the dissent. So it appears almost to be a question of when's the appropriate time to vacate the order. Is it once he's is it once he's no longer under supervision, or is it now? And my contention would be that he's on direct appeal now. This is a lifetime order that goes that will extend well beyond the period of post-release supervision. Mr. Strudwick is not that old. In all likelihood, he's going to complete his sentence and he will complete his post-release supervision. And at that point, he should not be subject to the SBM order, at least under these circumstances, an order that would have been imposed 35 to 48 years ahead of time.
I'm flipping through papers while I'm talking, and that's usually for me a dangerous thing to do. But the trial court's order appears to have been signed on December 19th of 2017 and is I'll stand 2 days later. Grady came out a year and a half after that, a year and a month or two after that. Does the fact that this order precedes the filing of our opinion, did Grady have any bearing on what we ought to do here?
I don't think so, Your Honor, and I guess that's a point I want to make clear. I believe that this case is controlled by the United States Supreme Court's decision in Grady versus North Carolina. Now, I think Grady 3 leads to the same conclusion, but it's not necessary for this court to expand Grady 3 in order to affirm the majority below. To balance a search's intrusion of an individual's Fourth Amendment interests against the promotion of legitimate governmental interests, it's simply not possible for a court to weigh these interests 3 or 4 decades ahead of time. And any attempt to balance those interests, and no matter how thoughtful it is, necessarily requires speculation about the distant future. And certainly a search of this magnitude, one that lasts for the duration of a person's life, should not be authorized on the basis of speculation. Instead, it should be authorized on the basis of circumstances that exist at the time the search begins. Now, as the majority pointed out, there's an easy fix for cases like this one. The General Assembly just needs to enact legislation that shifts the SBM eligibility determination from the time of sentencing to close to the time when the defendant is released from prison. And this would allow the court to evaluate the reasonableness of the search in light of whatever practices and technologies are, used to administer SBM at the time, the defendant's physical and psychological status at that time, any statistical and criminological analyses existing at that time that are relevant to determining SBM's effectiveness. And I would say that it's not at all clear that shifting the SBM determination to the point of the defendant's release or near that point would reduce the number of defendants subject to SBM. 3 to 4 decades is a long lead time for the state to develop empirical data that supports the purported effectiveness of the program that the state's arguing for throughout these cases.
Wouldn't the same argument hold 5 years, 10 years, 3 years? I mean, at what point do we, the court, draw a line that the General Assembly has not drawn?
Your Honor, I don't know. I frankly don't know the answer to that question. But what I can say is that 30 to 43 years is too far in the future, and that to affirm the majority below that's the only determination this court needs to make. Now, does that open up? It's possible that could open up other defendants, 3 years in the future. I'm not sure. Maybe the legislature can address that. But
let's say we did what you just suggested, affirm the trial court's order, and then the General Assembly takes the Board of Appeals up on its offer to enact a new statutory provision that authorizes satellite-based monitoring hearings, as you suggest, right about the time of release. Is there anything that would prohibit the enactment of such a statute and its application to the defendant in this case?
Your Honor, I'm not sure, but I can say that the state pursued SBM under this set of statutes, and these statutes do not provide for a second opportunity to impose satellite-based monitoring upon reversal of the order by an appellate court. So in this case, under these statutes, I don't think the remedy is a second remand hearing. Now, so if satellite-based monitoring affects the Fourth Amendment search, it needs to be reasonable. And to make that reasonable,
If we could go back, so it seems to me that what's being argued is, are you saying that this statute is unconstitutional as applied to your client?
that's correct, Your Honor.
Okay, so the way I'm understanding it is the remedy under a civil statute to make a motion with the court and or the remedy in the statute itself that is a 1 year bring back or 1 year after 1 year raise it to the commission, that those remedies, if you will, are inadequate. Tell me why they are inadequate.
The latter remedy is inadequate because it goes to an administrative body. It's not going to a judge to review the reasonableness of this search. The former remedy, if it exists at all, is, well, it's actually simply don't provide for such a remedy. There's no opportunity for the defendant to get judicial oversight of an existing satellite-based monitoring order once it's, after the period for an appeal has passed. And that's
How do we know that? I mean, are there any cases? Or are there? I mean, this is a civil remedy subject to the rules of civil procedure. How can we as a court just make an assumption that just because this is satellite-based monitoring, that there's no opportunity for a party to bring it back to a court?
Your Honor, I think it's because the statutes don't provide for such an opportunity. The remedy actually, or all the statute seems to provide is to be able to, after 1 year after post-release supervision is terminated, that the defendant goes to the parole commission. And at that point, and then I'm forgetting what the standard is, but it's vague. It's if the parole commission is satisfied that the defendant isn't dangerous. So we're not even getting under the statutes a reasonableness determination based on the facts at the time. And so essentially what the remedy is that the statutes provide for is an act of executive grace. And my contention would be that that's not sufficient. What there needs to be is judicial review of a search of this magnitude based on actual facts as they exist, not hypothetical facts that may exist decades in the future.
So you would concede that if the rules of civil procedure do allow a party to bring to a court the reasonableness of satellite-based monitoring, that at or near the time that the person will go off of parole, that would be enough to save the constitutionality of this statute?
I'm not sure I agree with you, Your Honor, on that point. The state has the burden of demonstrating this search. It would seem that if the defendant was put in a position, again, decades in the future, of being the moving party, that the defendant would have the burden of demonstrating that the search was unreasonable. It seems appropriate to pass constitutional muster that the state should have to meet its burden of demonstrating reasonableness at the time that the search, or near the time that the search would actually occur. So affirming the majority decision below will send a message to the General Assembly that needs to tweak the SPM program to bring it into conformity with the U.S. Supreme Court's decision.
Mr. Wilmer-Dieters, I have a quick question, I think. Talking about the adequacy of the remedy to bring it back to court at some point in the future, you can discuss it with Chief Justice Newby. If the rules of civil procedure apply, and an order was entered in this particular matter sometime soon on remand or whatever, saying that the state has not met its burden at this point of showing that it's a reasonable search of the Fourth Amendment, would you have a position as to whether the state could then bring a civil motion under Rule 60 sometime after his release to try to obtain relief from that order?
You're right. I have to, you cut out there. I'm sorry. I missed, I think, the latter half of your question.
Oh, sorry. Can you hear me now?
I can.
Okay. What I'm just wondering is that you indicated, or there was some questioning about whether the defendant would be able to come back in, and you thought that the defendant would then have the burden of making a new showing under Rule 60. And I'm just asking about the flip side of that coin. If it's a civil order, could the state come in after he's released and seek to get a new order based on new technology or whatever, referencing the efficacy of the program?
Not under the current statutes. I don't believe so. I mean, the statutes provided the state the opportunity, and it kind of required the state at the point of sentencing to demonstrate that to seek SBM at that time. There's no other opportunity. Now, again, this is not a bring back hearing situation, but the state does not have the opportunity to just invoke these statutes just down the road. And so I think that I don't think that's possible under the statutes as they're currently written.
So it would be your position that the General Assembly would have to amend the statutes to make some provision for parties to go back into court after the person has been released from prison and presumably from supervision?
That's correct, and I don't think it has to be after. I think it just needs to be near the time. I mean, it's one thing to project, a year or two into the future. It's quite another to project 30 to 43 years in the future. And a lot of these are very serious offenses, and a lot of these defendants are receiving lengthy sentences. And I think it's in the best interest, frankly, everybody's interest, to make these determinations at about the time when the search would commence. The statutes haven't been updated to, conform to the reality that Grady versus North Carolina imposed or created for the court. And so that needs to happen. And if the General Assembly needs to amend Section 14-208.40A so that an SBM determination is made near the time the defendant is released from prison rather than at the time of sentencing. And this will
that's not the situation in Grady. I mean, Grady was a bringback. There's nothing in Grady that addresses a situation of a defendant who has been convicted of one of the qualifying crimes other than recidivism. I mean, it's not, it's my reading of the majority in Grady is that's explicitly excluded. Is that not correct?
Oh, I agree. And that's why I'm saying that this court doesn't need to expand Grady in any way to affirm the majority opinion below. I think Grady.
But Grady doesn't control it then. So then it becomes, on its face, lifetime monitoring rendered at the time of sentencing, when at some other point in time it would become effective, becomes unconstitutional. That's really, in effect, what you're asking us to do, correct?
I think we agree on that point, Your Honor.
So is there any circumstance that lifetime monitoring is constitutional?
Not in this, under this circumstance. Is it? I don't believe that lifetime. I mean, we're getting beyond the scope of this case. I do not think that under the statutes as they're currently written, lifetime monitoring is constitutional.
So that would be a facial challenge to the lifetime aspect, correct?
But Your Honor, in this case, this is the Court of Appeals granted relief on the basis of an as-applied challenge. Mr. Strudwick brought an as-applied challenge. Now, he also made facial challenges, and those haven't been addressed by the court below I suppose if the court reverses the majority, then those determinations will have to be made, you know, on remand. But I think the appropriate thing for this court to do is to simply affirm the majority opinion. That will allow trial courts to make, you know, if that would communicate to the General Assembly the importance of again tweaking these statutes. We're not talking about a major reform here, and that would allow a contemporaneous reasonableness determination based on the actual facts at the time, rather than on speculation about what those facts may be decades in the future. And therefore, we respectfully ask this court to affirm the majority opinion. And if there are no further questions,
Thank you, counsel.
Thank you, Your Honor.
We'll hear rebuttal.
Yes, Your Honor. White versus Pate is this the court's position, and this goes back to the rational basis under due process, which is how we even get to the Fourth Amendment. And this court in Ryan versus Kmart has made clear that the rational basis review is satisfied so long as there is a plausible possible policy reason, and that this court should give deference to the legislature, and that I'm sorry. That speculation, and that the court does not have to do fact finding on whatever the legislative purpose is, and that speculation is not part of what this court's position would be for legislative purposes and the rational basis. So in other words, I think what the defense is trying to ask is that this court find that the rational basis is not constitutional, and that this court look beyond fact finding of the legislature, which is not what, according to this Supreme Court decisions, is allowable. And also the statutes, chapter 1A1, that is the general statutes for the civil procedures, which do apply to civil cases. And the state would only bring a matter under a motion in the cause or a Rule 60 motion if there were extraordinary circumstances, which is the case for the great offenders who are subject to grade E3, because there's nothing in grade E3 or the statutes under the SBM statutes. The state has been going back under the rules of civil procedure to terminate SBM for those defendants subject to termination by the virtue of being in the limited class for grade E3. But the Rule 60 is for either party. There's nothing that says that the defendant can't do it or the state, again, if there are extraordinary circumstances. The Court of Appeals essentially did err in expanding this court's jurisprudence by requiring the state to forecast future circumstances that have never been mandated. There's no law that says that's necessary. That this defendant, whether he's supervised or unsupervised, would have a continuum of relationship with the state, such that not unlike someone on probation or parole, because he's still subject to lifetime registration and would still be subject to lifetime monitoring, even if he's not supervised, he would still be eligible for going back to jail if he did not submit to those provisions. The Court of Appeals erred in ignoring the competent evidence. The Court of Appeals erred in ignoring the findings of fact that were binding on the court based on the competent evidence. The Court of Appeals erred in ignoring the conclusions of law that were accurately an accurate analysis of the law and therefore binding. And the Court of Appeals erred in placing the appellate burden on the state instead of the defendant to rebut the constitutionality of the statutes that are presumed to be constitutional. The state's burden was at trial. The defendant's burden is on appeal, and he did not meet that burden. And it was unchallenged because the Court of Appeals did not address his burden. They placed the burden on the state. The grade E3 does not apply insofar as its ultimate holding for the limited class of offenders for which state lifetime satellite-based monitoring is unconstitutional, in that this defendant, by virtue of having an aggravated offense and not being a recidivist only, is not subject to that limited holding. Therefore, this this defendant's satellite-based monitoring order is subject to the statutes that are constitutional, that this court has not held to be unconstitutional, such that the Court of Appeals erred in ignoring that and simply comparing one case to another, as opposed to looking at and applying to this particular defendant. The Grady 1 requires that there's an analysis as applied to the individual defendant, and that did not happen. We ask that you reverse the Court of Appeals opinion and affirm the trial court's order for lifetime satellite-based monitoring. Thank you.
Thank you, counsel. Thank you to both counsel. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess for 45 minutes. God save the state and this honorable court. Well, thank you both.